Hello, and welcome back to the Voloshen Law Firm for yet another episode of Power Partners. This is a video series where we talk about immigration law and how immigration law intersects with other areas of the law and other professional services. And today I'd like to discuss with Lidia the often forgotten and misunderstood topic of receipt of stolen property, which is a serious offense in most states, and it's misunderstood by a lot of my clients who truly feel that if they have received property which has been stolen, they have not violated any area of the law. Why are criminal charges being pursued against them? Lidia, welcome, and please tell our clients and our viewers what is receipt of stolen property and how it can impact their lives.
Igor, thank you for having me again. Always a pleasure. Receiving stolen property, as you said, often misunderstood area of law. Well, and you say often forgotten, that is true, by potential defendants, but not by the prosecutors. Actually, any theft, very often, more often than not, is charged as theft and receiving stolen property. So what is it? If someone took something without paying for it and then sold it or gave it to you, this is theft, no less than the original theft. And when your theft is often charged with receiving stolen property as well, is where the prosecutor or the Commonwealth, they try to cover all grounds in case your case takes a different way.
All steps in the
All
process.
steps in the process, and receiving stolen property is no less of a theft than plain vanilla theft. So, and naturally has the same process as any theft. It's an escalating offense, meaning it depends on the amount and how many times you did it, okay? Dangerous? Yes, because it's very tempting. This guy stole it, I didn't, let me take it. And then the consequences are criminal consequences. And again, as any theft, devastating immigration consequences.
And to piggyback on that, you said something which is very important to highlight, is that knowledge of whether it is stolen or not sometimes doesn't matter. Maybe you could talk a little bit more about, sort of, as we call mens rea, that guilty mind, the knowledge of the fact of that it was stolen or not, and also the difference between paying for the stolen good or receiving it as a compensation for as a non-monetary compensation for some kind of other services. My understanding, and please correct me if I'm wrong, it is still considered to be receipt of stolen property because you're still receiving benefit from the receipt of that property.
Well, yes. So to the first question, mens rea, very often there is what we call, an implied knowledge. We can prove knowledge. Again, by we still mean the Commonwealth. There is this presumption of innocence where the Commonwealth has the burden of proving everything. But more often than not, it's very easy to prove because, yes, you knew this was stolen, or you suspected, or you knew who this person was. They can build their case. That one thing. And then that is the biggest area, saying, I didn't pay for it. He just gave it to me for painting his wall. He paid you with stolen property for painting his wall. So if you know that whatever you received was not acquired by legal means, this is receiving stolen property. If you suspect, it may also be receiving stolen property and therefore theft. We're going back to that.
So something to keep in mind that, and to draw conclusions out of what Lidia said, is that if you are being given an item, a product, especially if it is something that has not only intrinsic value, but monetary value and significant monetary value especially, and you suspect, or you have a hunch, or you should have known on the standard of a reasonable person that that good or that product does not belong to the person who is giving it to you, or if you are not sure how that product was acquired or that item was acquired, the general rule should be that you should not accept it. You should definitely not accept it if there was prior conversation with you and the person giving it to you about illicit or illegal means that good was acquired in, because then you may also get charged with conspiracy.
Let me give you a very quick, very down-to-earth scenario that would kind of clarify all our legal talk. Someone comes and says, listen, my ex, here's her car, here are the keys, okay? While you are working on my new apartment, you can drive my ex's car. What do you think?
The car doesn't belong to them, and he's giving you possession
and she's an
without
ex,
consent.
so most likely she didn't. And then guess what? The value of the vehicle is any vehicle is very, very high, and you're in trouble.
Right.
So that's one of them. It's a very palpable scenario.
So the general rule is also that if you are suspecting that somebody is giving it to you something that they don't have legal right to possess, you should call and have a consultation with somebody, especially if it's an item that has high value and that you may get charged for. If it smells fishy, as we say, don't do it. Don't take it and do not accept that item.
In this area of law, I think legal term fishy is the best one.
Is the best.
Don't do it.
So once again, we thank you for your attention. We thank you for tuning in, for spending these a couple of minutes with us. If you have any questions, please contact our offices at 215-437-7854 or at voloshenlaw.com. Lydia, could you please tell our viewers how they can contact your office if they run into the accusations of receiving stolen property?
So it's law offices of Lidia Alperovich, and we are everywhere. The very old world way to contact us is 215-355-9105, but we're on Facebook, Instagram, groups, social, we're absolutely everywhere. So
once again, we thank you for your attention. Please tune in next time. Until next time, have a good day.
Good day.